The Texas Government Code is amended. I call an order meeting of the Board of Trustees of the Austin School District for Monday, February 20th, 2012 at 6:35 p.m. The board may meet in closed session to deliberate the appointment, employment, evaluation, assignment, reassignment, duties, discipline, or dismissal of public officer or employee, deliberation of purchase, exchange, lease, or value of real property, deliberation of negotiated contract for prospective gift to the district, deliberation about commercial or financial information the board has received from business prospect, or deliberation of the offer of a financial or other incentive to a business prospect, and or to consult with legal counsel regarding pending or contemplated litigation on or settlement offer or on a matter which the school's legal counsel determines to be confidential in accordance to Chapter 501 of the Texas Government Code, Sections 551.074, 551.072, 551.073, 551.087, and 551.071, respectively. Welcome, everybody. We need to scoot to the, we have a motion to approve the agenda.
That's great. I move approval.
Is there a second? Second. All in favor of that motion, please raise your right hand. Passed approved. Unanimously for members on the dais to do the pledge. Ms. Moya.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Welcome, everybody. Several interesting topics on tonight's agenda. We're going to start out first with the school finance litigation update. We have an hour scheduled for this item. Dr. Christarfin.
Mr. President, trustees, on October 24th, the board approved a resolution authorizing the district's participation in a school district lawsuit, a finance lawsuit, which was filed on December 22nd. This is one of 4 school finance lawsuits to be filed in recent months in the wake of the significant reductions to state funding for public education during the last legislative session. This evening, lead counsel David Thompson will provide an update on the litigation and answer any questions the board may have. Welcome, Mr. Thompson, and feel free to jump right in.
Good evening, members of the board, Superintendent Christarfin, and others. It's great to be with you tonight. I appreciate the opportunity to come and give you an update on the status of this litigation and have some discussion in public that will be similar to conversations that we've had in private. I would first like to introduce Holly McIntosh, who is an associate in our Austin office here. She has extensive background in school finance, having worked in the Capitol for Representative Scott Hochberg for 2 sessions. She is able to do modeling, and she's also worked in litigation in the Attorney General's office for the past 2 years, and we're happy to have her on our team. I will assure you at the outset, I will not filibuster. I know you've set aside an hour for this discussion, but I also know you have other important subjects on the agenda tonight. I will try to keep my remarks relatively brief and then spend the majority of our time responding to any questions you may have. As already has been said, 4 different lawsuits have been filed. There are rumors of a 5th lawsuit. If it develops, we'll see in the near future. But of the 4 that have been filed, they have all been consolidated for purposes of trial and assigned to Judge John Dietz, Travis County District Judge. We're very pleased with that because Judge Dietz was the trial judge last time and already has significant experience and familiarity with the issues, and we hope that will expedite the trial process. All of the different lawsuits are working together. The attorneys are talking on a regular basis. We will be submitting a joint proposed scheduling order in the near future. We know this is a matter of great urgency to districts, and we are approaching it with that same sense of urgency. We will be asking for a trial date this fall in October, with the expectation of completing trial and hopefully getting a positive decision at the district court level prior to the beginning of the legislative session in 2013. So we're going to push hard on it and try to get a resolution sooner rather than later. That's the way we will approach it, and all of the groups are working together on that. I do want to let you know that our group, the Fort Bend ISD group, they're the lead name district, but Austin is one of the very important, significant members of this group. Our group is composed of both Chapter 41 and Chapter 42 districts working together. We currently have over 1.8 million students that are already members of our coalition, with more joining literally on a weekly basis. And just to put that in perspective, this is far and away the largest of the different groups this time around. In fact, our group in terms of students is larger than all the other groups combined. And it's the largest single group there has ever been in the history of school finance litigation in Texas. So it's a very significant presence, and we think that alone makes a statement. I think by the time we get to trial, well over half of the districts in the state and well over 2/3 of the students in the state will be participating in one of the different groups. So we're going to coordinate. We've already got a trial court assigned, and we're pressing for trial sooner rather than later. And so just from a status, that's a quick update in that regard. Mr. President, Madam Superintendent, I have a PowerPoint. I think, have you all been provided copies of this? I'm going to hit a couple of the slides just to make some observations, and then again, save most of our time for any questions the board might have. Holly, if you'd hit the next slide. Yeah, just hit the advance button. This is just the point I want to make here is if you look over the last 30 years, we see a pattern in Texas. I wish it weren't this way, but it's almost sort of a call response, point counterpoint pattern of virtually all of the significant changes in school finance in Texas over the last 3 decades have come as a result of a court decision. In the last 30 years, we have had 6 cases get to the Supreme Court. This will be the 7th. I'm confident it will reach the Supreme Court. Out of the previous 6 cases, the state has prevailed exactly 1 time. So we hope to continue that pattern, and that's our objective. But some people may say, well, why did we have to file a lawsuit? What is the lawsuit? Why are we doing that with regard to school funding? Why don't we just work with the legislature, or comments of that matter? The only point I want to make here is, for whatever reason, this is the way we tend to do this in Texas. The observation I've made to a number of civic groups when I speak about this is I ask people, I say, quick, don't look at your neighbor, give me an honest response. How many people have a 2-car garage? And usually most are greater, and usually most people will hold their hands up. I say, now don't look around, be honest. How many people, if you went home today, could get 2 cars in your garage? And about half of the heads usually go down. The point is, we all have fairly large, complex jobs that tend to get put off until we have to deal with them. And unfortunately, at the state level, I think school funding falls in that category, and I do think a decision from the Supreme Court will actually be very helpful to the legislature in making some significant substantive advances. Just keep hitting it till they all come up. As you know, the 2 key provisions of our Constitution that all of this litigation flow from, first of all, Article 7, Section 1 of our Constitution. Very important provision. All of Article 7 deals with education, not only public education, but community and junior colleges, higher education. That's what Article 7 is about. It starts with these words that have been unchanged since 1876. A general diffusion of knowledge being essential to the preservation of the liberties and rights of the people, comma. Now, just stop right there for a minute. That tells you why we believe in public education in Texas and why Texans have always believed in public education going back to the 1800s. That notion that an educated society and a healthy society are interrelated is at the heart of why we have a school system and an expectation for public schools in the state. If you continue reading, that section then speaks in language you don't see elsewhere in our Constitution. It shall be the duty of the legislature to establish and make suitable provision for the support and maintenance of an efficient system of public free schools. That's sort of the how, if you will. The why is because an educated society is essential to a healthy society. And then the how are the duties that flow from that to the legislature. And these are non-delegable, non-discretionary, they're absolute duties. A duty to establish, a duty to suitably or adequately provide, and a duty for the system itself to be an efficient system. Another key provision that we tend to talk about in Texas is Article 8, Section 1E, which prohibits a state property tax. And our court has noted many times, going back to the 1990s, that the legislature can run afoul of this provision by having a system that is so reliant on local property taxes that local districts, local boards no longer have meaningful discretion over your own taxes. And so my question that I ask many times to school districts is, how many of you felt like you had a lot of discretion this year? The discretion you had, I suspect, was simply what to cut out that your community thought was important. That's not what the Constitution has in mind. So this litigation flows from these provisions of our state Constitution. These are not new issues. Our Supreme Court has spoken to them many times in the past, and we're going to seek their interpretation and strong voice again on this. You can move past that. This is just language from the Supreme Court from the last time. Again, this isn't, again, it isn't new. Our Supreme Court, by the way, in 2005, every justice that is still on the court who participated in the decision in 2005 ruled in our favor and participated in this decision. And you can see the language that it's the degree of state control over the local property tax, either directly or indirectly, and whether the local district has meaningful discretion. And I want you to read the key phrase at the bottom. This is verbatim from the Supreme Court's opinion. The state cannot provide for local supplementation, then pressure most of the districts by increasing accreditation standards in an environment of increasing costs to tax at maximum rates in order to afford any supplementation at all, and then argued that it's not controlling the tax rates. Our Supreme Court has spoken pretty clearly on this. We believe this is exactly what has happened if we look over the last several years, and that will be one of the key arguments that we will be focusing on. Just a slide that shows the distribution of tax rates in Texas. Let's move on. Another key issue that our court spoke to in 2005 that we will press heavily is the adequacy argument. So one argument, state property tax. A second argument is an adequacy argument that really flows from that duty of Article 7, Section 1 to not only have an efficient system, but to suitably provide for that system that you've just created. And our view of the adequacy argument, just to be clear, and I think we've had this conversation previously, we're not asking the trial court or the Supreme Court to invent out of thin air how much they think is enough. We're not asking them to just kind of be an activist court and to take it upon themselves to identify how much money or how many resources ought to be devoted to public education. Our argument is that the state has already defined a very high standard of expectations for school districts. When we look at the recommended curriculum, when we look at the end-of-course exams and STAR exams that are being phased in, when we look at the 4x4 commitment, post-secondary readiness, all of these requirements together, and indeed, if you look nationally, Texas gets relatively high marks for setting high standards or setting high expectations. The adequacy argument is once we set the standards, we have to have a funding system that actually supports and is tied to the very standards that the state itself has set. We used to do studies in Texas at the state level to determine the cost of our own requirements. We stopped doing those studies several years ago. Why did we stop doing the studies? Because they didn't like the answer. Our own studies and the state's own studies kept saying over and over, if we're going to get a growing population to high standards, it's going to take some resources. We simply quit doing the studies. It's sort of like a person stopping going to your doctor because you just don't like the advice or the diagnosis that you're getting. We're going to try to correct that. But that's all we mean when we talk about adequacy, is take our high standards and then have a funding system that actually rises and is tied to our own requirements. Next slide. Just a quick observation. When we talk about adequacy, I just think this is good information for everyone to keep an eye on. If we go back to the last Supreme Court decision in 2005 and then pick up with the school year, the next school year after that, and just look at what has happened to our demographics in Texas, it's pretty amazing. When you look at our demographics, we are a dramatically growing state. We're adding roughly 85,000 students a year.